The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barquette, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. Alongside Dan Grimm, I'm Matt Glenn. We're from Cook, Barquette, Ponder, and Wolves. And today we're going to be talking to you about depositions that occur in personal injury cases. Dan, this is something that depositions can be really kind of the most important part of really any injury case.
Oh, absolutely. It's just, and depositions for our clients, for the plaintiffs in the case, are a lot of times anxiety-ridden because they don't know what to expect and they've never done it before. But like you said, why it's important is because their credibility is at stake.
Right.
And so, yeah, so depositions is a key part of every case. So
when you're getting our clients ready for a deposition, there are a lot of things we walk them through, and this is one of the things that I know you do a lot of. So what are some of the early things you talk to our clients about in terms of getting ready for the deposition?
Absolutely. So first of all, I give them a rundown as far as what to expect, what a deposition is, to try to calm their nerves. Typically, I like to meet with the clients well in advance of their scheduled deposition, and often we do it over several days. Mm-hmm. So some of the things we talk about, obviously, is the facts of in this case, say it's a car crash, the facts of the car crash, what they remember. Again, because what we want is them, when they walk in a deposition, to have a clear understanding of the questions that may be asked, and for them to not to do anything that may misstate something that they said before.
Yeah.
And the reason why is because on the defense side, any misstatement is going to be spotlighted as a lie.
Right. And oftentimes our clients have given an initial sort of statement of facts to an insurance company before they get in our office.
Right.
And we want to make sure that their statement is consistent with their memory at the time. There are a lot of ways that when you're talking about the facts of something that our clients can, they don't realize they're being inaccurate, but they are. You're constantly giving advice. Well, I mean, for example, like, what do you talk to our clients about in terms of time and distance?
Well, the same thing. It's a lot of times I ask them, if you're asked that question, just in a way, don't give a time distance because it's not going to match up to what reality is.
Yeah.
And just they're going to say, well, to my best guess, and we always tell our clients, we don't want you to guess.
Right.
If you don't know, you don't know.
Right.
Because again, it's going to be spotlighted as an inaccuracy, which on the defense side, they blow it up as quote unquote a lie.
Yeah. I mean, you might have experienced everything happening at once. It all
Right.
happens at once.
Right.
But then if you say, I noticed it 3 seconds ahead of time. Well, 3 seconds can be a long time if you're just, that's long enough to react.
Right. And that's why we go through, again, we break down in our prep session. We break down as far as the facts of the case and what they remember. So that way, again, they're as accurate as possible and it doesn't affect their credibility in the case.
So the last thing you want is your client to guess on something and guess in a way that hurts their case.
Absolutely.
Then they're being inaccurate and counterproductive.
And it's helpful for the client to walk through it prior to the deposition with their attorney and talk about it.
Yeah, in a safe space. Well, a lot of our clients also have, prior claims. They have prior issues with the parts of their body they've injured. How do you navigate that? How do you help our clients with those issues?
And that's exactly it. If I always told clients, like, if somebody asked me, about my medical history for the last 10 years, I could only give you a fraction of what my medical history is. Right. And it's not that they're being deceptive. They just don't remember because they've lived a lot of life.
Right.
So it's important to go through their medical history, take time with the client prior to the deposition. So if there was, say, a prior neck injury or a back injury or a sore neck or a sore back, that they can articulate that at some point in time they lived a life that they may have slept wrong or they twisted it wrong. But that way they can talk about it and put it in context.
Yeah, a lot of times it's such a minor thing that they don't remember it.
Absolutely.
They don't remember going to see this chiropractor for 2 visits or saying to their doctor, I can't seem to shake this soreness in my neck. Can I get a muscle relaxer or something?
Right.
And it's a blip, and they move on from it. But you're exactly right. If you say, I've never had a neck issue, and they find evidence that, oh no, on the 28th of October 2014 you did,
Right.
you know, then you have to explain it after you've, you know, theoretically been untruthful about it. And that it's so much easier if you get out ahead of that. Oh yeah, it hurt for one day. I went to the doctor and I was fine. And you'll see no evidence of follow-up treatment. That's an accurate story.
Right.
But our clients need a lot of times to have their memory refreshed.
Right, and it's so good to, again, spend time with the client going through that medical history, because once you start going through it, then it helps refresh your recollection. They remember, then they can put context of whatever the medical record says.
Exactly. And also you're going to have them talk a lot, I assume, about you know, the injuries they sustained in the accident.
Absolutely. That's something that, you know, on the defense side, they always want to know, well, what were you complaining about? What happened? What was hurting at the time of the crash? Because sometimes you have a situation where somebody was knocked out in a car crash or their bell was wrong. And then sometimes the records don't accurately show in the medical, if they go to ER, what was hurting at that time. So they got transferred to ER immediately after the crash. Well, maybe the pain didn't start till 2 or 3 days later. Well, it's not going to show up in ER records.
Right.
So you need, later in the medical treatment, they talk about issues that maybe they didn't talk about the ER.
Right.
Well, it's important to put that in context as to why maybe it wasn't in the medical record at that time.
Yeah, I have a client right now who, when he got transported from the scene of the accident by helicopter, and I mean his lower leg was shattered. It took 2 surgeries to put it back together. He laid in a hospital bed for 4 or 5 days before he could even think about getting up. And yeah, he also has some neck issues and some back issues. He didn't feel those.
Right.
You know, he doesn't remember the ride to the hospital. He doesn't, you know, he woke up in the hospital a day or 2 after the accident, for the first time understood where he was. You know, that type of immediacy of pain isn't going to be there. He even thought, they've discovered since he has a traumatic brain injury.
Right.
We don't yet know how bad it is. But he didn't notice it for 3 months after the accident. He thought his brain was foggy because of the medication he was on. So, I mean, the onset of the symptoms, it's really important to have honest conversations with your doctors and your lawyers so that you can tell an honest history of how you're doing.
Right. And I'm sure in that case, again, the chief complaint was this horrific injury to the leg.
Exactly.
And then once that resolves, oftentimes that you're like, okay, my neck is hurting or my back is hurting,
Right.
but it was masked because of the pain in the leg.
Right. And many times that happens a lot. Even when the injury is not that serious, you might have really wrenched your knee and your leg is really hurting, and you just don't notice that your neck is also hurting because this pain overwhelms everything else. It's the old, when you were a kid and you had a headache and somebody slugged you in the arm and the headache went away, right? Then your arm was throbbing. Don't recommend that. Don't try it at home, kids. One of the areas that always gets brought up during a deposition that our clients can feel uncomfortable about can be a criminal history. How do you deal with that issue?
And that's something we see quite a bit because I think a lot of times, obviously, the clients that may have had something to happen in past, a criminal history, they're embarrassed and they don't want to tell their attorney. That's, again, something that we need to have the honest conversation with the client about because we can deal with that issue in trial.
Right.
But what we can't deal with is a lie about your past, about your criminal history, because that will come in.
Yeah.
So often we go through, we'll run our clients on CaseNet, we can do ISL reports, and also what we tell the clients that on the defense side, they're going to be doing the exact same thing.
Yes.
So there's no reason to try to pretend that it's not there. So we want to have an honest conversation talk about it, put it in context, and then move on.
Yeah. Yeah, it's like we always tell our clients, we can fix anything except the lie. I mean, you almost never have somebody who's lived a perfect life. Everyone makes mistakes, and they're usually not a big deal. Oftentimes, they're not even admitted into evidence at trial.
That's right.
It's just a few uncomfortable questions that you deal with, and then you move on from them. And as long as our clients are honest about it, it usually ends pretty well for them.
And again, to reiterate, the reason why this is so important because at trial, our client's credibility is of the utmost importance. Right. And a simple mistake like this, as far as not being honest about something, can just shed your credibility and your veracity to tell the truth.
Yeah.
So it's something that, again, that's where preparation with the client before the deposition, before you're under oath, to get everything in context. That way there's an accurate story moving forward.
Right. So in addition to a criminal history, though, we're also looking at, especially in a car accident case, their driving history. How do you go about handling that?
Again, same thing. You can pull these up on Regis or ISO reports. Again, on the defense side, the defense attorneys, they're doing the same thing. So they'll often ask clients in deposition about any prior motor vehicles. Again, just like any of us, we've all lived, a long life. And there's a lot of things that you may not remember, whether or not you filed a claim or not filed, or you did file a claim. So part of our part is kind of going through the client's history with the client, with the, with the ISO report or the Regis report, to talk about as far as, what was this a crash or was this a property damage claim or,
Right.
What's going on here. And a lot of it is just helping the client remember, what happened 10, 20, 30 years ago. Because again, on the other side, if the defense counsel has the same information we have, they're going to know about it.
Right. Yeah, oftentimes I don't know that I could tell you every single time I've been pulled over in my life or which of those times happened in the last 10 years and which did not.
Right.
I think it's been a while since I've been pulled over. But it's I can't sit here and just recite them all.
No.
And that, a lot of times when our clients get under oath, they feel this sort of pressure to give an answer, right? That they're supposed to have an answer for this. And many times they don't, but you're right. If you refresh their memory, if you walk them through, hey, this is what we're seeing, this is what we found, tell me about this. I'm like, oh yeah, I'm just going 10 over and I got pulled over and paid the ticket,
And it just, like you said, just takes time because all of us have so much going on, so much, with our work, our family, our responsibilities, that a lot of stuff is just a distant memory that has been long forgotten. And just takes time with the clients to kind of go through this. And again, once you spend time with the clients talking about it, they're like, oh, that's right, I do remember this. And then
Right.
during the deposition, it comes off as smooth and no problem, no issue at all.
Yeah, exactly. Well, you wind up putting the best possible face on your story, and
Right.
that's ultimately what we do. We tell their story, and the deposition is where they help. One of the big areas of inquiry for our clients during their deposition is their treatment, their treatment after the accident, and how that's going. What sort of things do you look for there?
So same thing. So we go through the medical records, and then just go through the treatment dates, through where if it started in an ambulance to the ER to just we go through and then we go through the medical records because a lot of times the clients don't remember statements that they may have said to the doctor, which are clearly in the medical records. But again, it's the clients don't recall saying that. So a lot of times we'll spend time going through the records, what the chief complaints were, what parts of the body were they complaining of as far as injuries, and just go through. So that way it comes at depositions. It's a clean, accurate summary of your medical treatment because they're going to be asked about that in every single deposition.
Right. No, I mean, when I was a defense attorney, I had a summary of their medical records
That's right.
directly in front of me, and I can go through date by date by date to confirm that's how they were feeling. And yeah, I could tell the ones that had reviewed that history and the ones who had not.
Right.
I could tell who was prepared and who wasn't.
Right.
But in addition to their medical treatment, that's usually, fairly black and white. It's written down in records. But our clients also have what we call human losses. How do you go through those with our clients?
And that's exactly right. Is that the biggest part of the case is that all of us are unique and we have lives that we live, that we have passions and hobbies and we have family and things we love doing. And these injuries often affect those things that are most important in our life, which are our family, friends, passions, hobbies, work, and activities. That these injuries have emotional components to it that often people are depressed or sad or frustrated because the life they once had has been forever lost.
Right.
So going through those emotional harms with our clients is imperative because a lot of times they haven't articulated it.
Yeah.
And so it's important trying to get it. They thought about it, they lived it, they suppressed it, but trying to articulate it when a stranger, a defense attorney is asking you questions, sometimes can be difficult if you haven't gone through the exercise before.
Yeah, many times we find that it's really our client's spouse or family member that can tell us more about those
That's right.
losses
That's
than the
absolutely
actual
right.
person can. A lot of people don't like to look like they're complaining. They don't like to feel like they're whining. But at the same time, their spouse can come in and say, he used to light up every room he walked
Right.
into, and now it's just a totally flat affect. I mean, it
Right.
just isn't there anymore. So things like that, we uncover them during the depot prep and make sure those stories get told.
That's right, because it's a lot of times, like you said, people are private, it's uncomfortable, but that part of the injured victim's story is vital to be told.
Absolutely. Well, that does it for our first segment. We'll be back in a few moments to talk more about depositions. We appreciate you listening. Stick around to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation.
Cook, Barquette, Ponder, and Wolz are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to segment 2 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. With Dan Grimm, I'm Matt Glenn. We are partners at Cook, Barquette, Ponder, Wolz. You can find us on the web at www.cbpw-law.com or contact the office at 573-335-6651. We're talking today about depositions and the impact that they have on our litigation. The first half of the show, we talked about the party depositions. In the second half, we're going to go more into the expert side of things.
Yeah, and I think, like I said, what you see in motor vehicle crashes, as far as expert depositions, what are some of the standard or typical expert depositions you see?
Well, in every single injury case, you're going to have a doctor testify. The client or the plaintiff is not capable of going into a courtroom and saying, you know what, I need to fix me, I need a surgery, or I need this injection and I'm going to need them moving forward. So the one constant in all of our cases is we need to get a doctor to come in and help us sort through the injury. We use that mainly. We try to use treating physicians. You mentioned credibility earlier. Juries are naturally skeptical of a party when they testify. They're skeptical of the plaintiff because the plaintiff wants to get money. They're skeptical of the defendant because the defendant doesn't want to lose. Oftentimes, a treating doctor they look at as, their goal was to fix this person, to make them better. And many times that gives them added credibility. So we look to the treating physician to testify. They're required to testify to a reasonable degree of medical certainty. And they're required also to, not required, but they provide us with sort of a diagnosis. They provide us with causation. This injury was more likely than not caused by this accident. And then a treatment plan of how to get them back to where they were before the accident.
Right, and so that's something that in every case, every personal injury case, you'll have a treating doctor. So when you take the doctor's depositions, are you often looking for as far as opinions about future care as well?
Absolutely. Yeah, and that's the one area where doctors tend to struggle the most because they can't predict the future any more than any of us can. But what they can tell us and what they often do tell us is what our clients are now at increased risk for. Whereas before they may have had a risk of arthritis, now that risk has doubled, maybe tripled. They have an increased risk then of being in pain later in their life. They have an increased risk of perhaps needing surgery. Sometimes the doctors can say, yeah, well, with this ankle, I've operated on it. I've repaired it as best I can. They're going to live on it for as long as they possibly can. But then that joint is going to need to be replaced, or that knee will need to be replaced. Many times a hip, if a patient is a certain age, a hip will eventually need to be replaced, depending on how long the person's expected to live. So they can give us a projection of, this is what their future looks like. This is the care and treatment they're going to need. And so we work with a treating doctor to figure out what that care is, and then we worked with other experts to talk about how much that's going to cost.
Right. And you use that word causation. For the folks at home, kind of maybe give an example of what causation is.
So what a doctor will do is he will testify in his expert opinion to what they call a reasonable degree of medical certainty. And he's looking or she's looking to talk about the relationship between the injury, the traumatic event, whether it's a fall or a car accident, and the symptoms that the client is having. Usually it's a matter of, they experience the impact, the pain begins shortly thereafter. Therefore, this trauma is most likely the cause of this pain. Sometimes there's a delay in the symptom onset. Sometimes the doctors can still relate it, and sometimes they can't. But we're looking for them to say, these are the injuries that were caused by this car accident or this fall, and this is the treatment needed to then put them back to where they were the day before this injury happened.
Right. And that can be done just on the plaintiff's testimony. You need a treating doctor, an expert to tie it up.
Yeah, you need a scientist.
Right.
You need a physician to testify to like I said, a reasonable degree of medical certainty.
So then I guess, and sticking with car accidents or motor vehicle crashes, what's another expert deposition that you typically see?
Well, so one of the ones, especially if liability is at issue, if we don't really know who is at fault for an accident, we will get what is known as an accident reconstructionist. This is an engineer who can go out, they can measure skid marks, they can measure the dents in the vehicles, they can look at the damage, they can see markings on the roadways. They can oftentimes download data from inside the vehicle, and they can see then how fast the vehicle was traveling just before the collision. And they can take all of that and sort of reconstruct the accident. They can tell us the story of, from a scientific point of view, this is how the accident happened. It can be really valuable testimony, especially I had a case a few years ago where our client had a stop sign, and then she began crossing a road, and the back end of her car was hit by a delivery truck. And she was spun off into the ditch. She hit her head. She couldn't remember the accident at all. And she could tell us, I'm typically very careful. I typically look both ways before I cross the street. And I assume I believed that I could have made it. Otherwise, I wouldn't have started across the street. The driver of the delivery truck testified that, that he was going straight. She pulled out right in front of him. He tried to hit his brakes, was unable to, and struck the rear of her. Well, that looks like, the first time you hear that story, it looks like our client's going to lose. She had the stop sign. The truck driver didn't. The truck driver remembers the accident. Our client didn't. But what our reconstructionist was able to do through his investigation was he was able to figure out that the delivery truck was actually exceeding the speed limit by 15 miles an hour. And he, through his measurements, said if he had been going the speed limit, if he had been abiding by the law, she would have safely crossed. So she's only failing to yield the right-of-way if the oncoming traffic is actually going the speed limit, right? She would have made it had he not been breaking the law. So that wound up being a case that we were able to settle because we were able to show, our expert was able to show that, hey, this isn't just one person's fault. This is also the delivery truck who was driving too fast.
Right. That's great work.
Yeah.
And we always talk about it. It's so important for the plaintiff, the injured party, to get us involved early in the case.
Right.
And this is a perfect example, right?
Exactly. I mean, the skid marks at an accident scene don't last forever. Oftentimes there are gouges in the pavement that get repaired soon after an accident.
Debris fields.
The dents to the cars are fixed, or the car is sent out for scrap and lost forever. The data that you want to download from both vehicles, that data doesn't last forever. We send out a preservation of evidence letter the first day we get a case to the defendant, telling them, hey, you may have a lot of this information, the data, you may have photographs, you may have witness statements. You need to save all of it, and that triggers their responsibility to do that. And the earlier on in the process we are, the better the data is for the reconstructionist, and the better the data that they get, the more certain they are in their conclusions.
Absolutely. So let's kind of move away from motor vehicle crashes. What's some other type of expert depositions that you've seen and done involving different cases you've handled?
So we do a lot of products liability cases in our office. We will bring a suit against a manufacturer of a product if that product is unreasonably dangerous. You cannot do those cases without an expert. It is absolutely impossible. You need an engineer or some other expert to look at the product and say, that product is unreasonably dangerous. And also, it could have been made safe. Either they could have gone with a better design, or they could have put a guard of some kind on the product to make it safer, or they could have issued a warning that, hey, you don't want to do X, Y, and Z with this product because it can cause an injury. We had a really simple one. It was a wheelchair case in our office some years ago where our client's father was trying to cross the street. It was at night, and he's in a wheelchair, and a car came along and hit the side of him and killed him. He passed away. We believe he was in the crosswalk. We believe it was legal for him to cross, but it was dark. The driver couldn't see him. And the wheelchair, it was a motorized wheelchair, and it was all black and had absolutely no reflectors, no lights, no reflective material on it at all. The manual didn't say anything about, hey, don't drive this at night or don't cross streets. The manufacturer had to acknowledge that people do operate these things on sidewalks, and that when they get to a street corner, they will cross the street, just as my client did. And our expert told us, it would have been 75 cents for this company to buy some reflective tape as part of the manufacturing process and decorate the outside of this wheelchair with that tape. And that reflective tape would have saved my client's life. It's an example of a case where we really felt strongly that we were asking questions of this company that they should have been asking themselves.
Right.
And our engineer was able to come up with creative solutions that were not expensive, and we were able to put those solutions in front of this company. Now, we wound up settling the case at one point, and that's great. That's a nice result for our client. But what my client has told me the times I've talked to her since is every once in a while she'll see a wheelchair heading down the street with reflectors on the back of it, or with reflective tape on the side of it. And it kind of makes her smile. She kind of feels like, maybe I had a hand in helping make that happen.
Absolutely. And you see that quite often in these product liability cases that we're actually making a company to produce a safer design.
Yeah. Oh, yeah. Cars are a lot safer now than they were 40 years ago. And they're safer, because I think we had them on our second or third week, Phil Barquette.
Right.
He's been practicing law for over 40 years. The car you ride in now is safer because of people like Phil, who would sue the manufacturer of a vehicle if they didn't make it in a safe way. We always talked about the Pinto case, where they knew Ford was told by their engineers, hey, a certain number of these cars are going to explode, and this is what it'll cost to stop that from happening. They made the determination, yeah, that's just too expensive. We're just going to go ahead and let this go. When companies do that, an engineer will step in and give a deposition that, hey, this other design would have been better. They could have done it. It was feasible. And then the car would not have been unreasonably dangerous.
That's right. We also see, like, in a lot of, like, machinery cases, failure to guard issues or lockout, tagout issues. Right. And we have a couple in the office right now that are basic, horrific injuries because of failure to guard.
Sure. We had a one from a factory that we've settled, and it was a machine that helped process animal food, process some animals. I don't want to say which ones, but there are guards on these. They're blades. They spin. They carry the animal through the assembly line and basically help clean the animal. To clean those machines, which obviously is very important, you're dealing with raw meat. You need to do what they call lockout, tagout. There's always a box where you can, operate this machine, start the assembly line, and that box needs to be locked up. And basically, you turn that machine off, and then you lock the on-off switch up, and then you can go about fixing the machine or cleaning the machine. There are some cases where the lock doesn't work or something gets broken. In those cases, they should not operate that machine. And we see from time to time that, those are the steps you're supposed to take with lockout, tagout. You're supposed to have that safety, that guard available. If they don't have that, then the product is defective.
Right. It's sad is to think about how many injuries or death or catastrophic injuries that could have been avoided because of these safety measures.
And they're awful injuries, and that you're talking about a machine grabbing your hand and basically ripping the skin right off of it. It is gruesome to think about. I can tell you it's not fun to see. But those are the types of injuries that happen when you have large machinery that isn't made as safe as it ought to be.
Right. What about, another expert that I think is I've seen quite a bit of is an epidemiologist. Let's talk about that.
So epidemiology is a fascinating field. It grew up in the mid 1800s. It grew out of a cholera outbreak in London. The scientists and the doctors could not figure out why certain people were getting cholera. They didn't know if it was being transmitted through air particles, person-to-person contact, or through liquids, or what. And they eventually started tracking who the people were that were getting cholera. And they would ask them, where have you been during the last 7 days? And they eventually got everyone back to one water pump in the middle of London that was too close to where people were using the restroom. And even though they couldn't say scientifically what cholera was or how it got transmitted, they could trace it all back to this water pump. And so an epidemiologist can tell us that many times when science doesn't know why something happens, the epidemiologist can still make a connection between, in that case, a water pump and the cholera. Another example is in tobacco litigation. Scientists don't know what causes cancer. They don't know what causes the lungs to begin to become cancerous. But they do know that 30 to 40 times more, you're 30 to 40 times more likely to get lung cancer if you smoke than if you don't. They're able to look at a population of smokers versus a population of non-smokers, and they see just a huge increase in the number of people who will develop lung cancer. That enables an epidemiologist to say there is a correlation that is actual causation between smoking and causing cancer. They can draw that line, whereas scientists at this point can't say what triggers that cancerous growth. They can't yet medically say that, but we know there's a connection between the two, and that's where the epidemiologist comes in.
These experts are fascinating, and there's many more experts, but we're out of time.
We are. Our apologies to Mike Ponder. We ran out of time. That does it for us on Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Dan Graham and all of us at Cook, Barquette, Ponder, and Wolves, thanks for listening.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.